Go.
Hello again, everyone. I'm Zachary Lawrence of Parkside Property Management. Always a pleasure to be here with my friend, mentor, and eviction expert, Dennis Block. Give me a fist bump. There we go.
Fist bump for the camera.
go.
Hello, everybody. And we have another podcast. We haven't done one for a while, but I am very excited about today. Before we start,
Yes,
I want to talk about some newsworthy event.
the camera's right there. Knock yourself out.
And that's what I'm going to do. There is going to be on the ballot next year a initiative that has been done by tenants groups to repeal Costa-Hawkins. Costa-Hawkins was one of the few legislative amendments that was in favor of landlords. It prevented new municipalities from instituting rent control. It did away with vacancy decontrol, which meant that in Santa Monica, for example, many years ago, you had a situation where if your tenant moved out voluntarily, you still were not able to raise the rent. Well, Costa-Hawkins solved that, and it also said that if a municipality hadn't instituted rent control by 1995, then they couldn't add one now. Well, this is all on the slaughtering block, so to speak, because if this initiative passes, then what's going to happen, my good friend Zach, is that cities that didn't have rent control, like Manhattan Beach, I think that's where you're from, and Culver City and Long Beach.
Go ahead.
But they can start instituting rent control. In addition, the city of Los Angeles is now considering, even if this initiative doesn't pass, where you're going to have good cause to evict tenants, even in non-rent control properties, such as a single-family home, or if the building is considered new construction, it wasn't under rent control. But now you're going to need to have good cause eviction.
Great question. What is the difference between good cause eviction and just cause eviction?
There really is no difference. They both are synonymous. It's funny that I got that question today. But they're both synonymous. In other words, that you're going to have a specific reason why you want to evict the tenant. For example, a violation of a contract, brought in a pet, or alterations to that degree. So if you're in a situation now where you have these bad laws that are looming to be passed, my advice to everybody is, if you have a property that is not under rent control, make sure right now that every one of your tenants' rents are brought to market level. Serve your rent increases now, because you're going to get foreclosed from doing that once this law passes.
Is there a window of time, Dennis? For example, let's say the law is scheduled to pass, and for the sake of this discussion, in a month from now, could you raise your rents in 3 weeks from now and still have that stand up?
Well, what happened back in 1979 when LA introduced rent control, they did make everybody roll their rents back to the year before. So that can happen even now, but at the very minimum, we're not sure exactly when this is going to pass or not. So if you have the ability right now, raise your rents to market value. But that's not all. Let's pretend you have market value rents for a specific unit, but you have something there that's called a malcontent. That's the one tenant in your building that's always calling you up, always claiming things are wrong, always making it much more expensive for you to run your property. That's the person that you should serve a 60-day notice or a 30-day notice, assuming they're on a month-to-month tenancy. And this way you'll get rid of this person. Once this law comes into effect, what's going to happen is you're going to be stuck with this tenant. There's going to be no effective way to get rid of this tenant, and it's just going to make your life on the property very miserable. So once again, this law is going to be passing. I feel it. I can taste it. If you've got rents that are below market value, right now, this moment from hearing this, make sure that you raise your rents to market level. And also, if you've got tenants which you could deem to be a malcontent, don't put up with it. Serve a 60-day notice if they've been there longer than 1 year, and terminate that tenancy. That's my proviso for today.
Okay, so basically you're saying that the city of Los Angeles will maintain rent control, but there are jurisdictions such as Manhattan Beach, as you mentioned, that currently do not have any restrictions as far as evicting somebody, or terminating a lease. And if this law passes, Dennis, a landlord will have to have either good cause or just cause in order to say adios.
Correct. They won't be able to raise the rent to market level, and also they'll have good or just cause requirements in order to have a tenancy terminated.
Well, wait a minute. If they can't raise it to market level and the unit is vacant, what is the criteria for determining the base rent?
Well, if the unit is vacant, then I don't think the law will change where they won't be able to raise the rent to market level. That is certainly possible, but I think you'll be able to raise the rent to market level. But the problem will be for those tenants that you're in your building, it's not under rent control, but the market value of that unit is low. So many landlords in 1979 got stuck. They hadn't raised the rents for years. They didn't care. They wanted to be nice to their tenants. Those were the landlords, the nice guys, that got killed once rent control came. Those were the ones with a 2-bedroom apartment for $417 and they were stuck. And to this day, those apartments probably have been handed down to the children, and it seriously affected their income, seriously affected the value of their units.
Okay, so what you're saying, for example, if this law passes in Manhattan Beach and a 1-bedroom is going for $1,000, and the landlord cannot, and there's another 1-bedroom across the street going for $2,000, you're saying that if this law passes, the landlord, the $1,000 a month landlord, cannot raise the rent to $2,000 a month. Yes,
because even though the property wasn't under rent control, once it's instituted, that's going to be your base rent, and you're stuck with that situation.
In a situation like that, who is the arbiter of what the market, what the base rent is? In other words,
it's what the existing tenant was paying.
Okay, so I'm paying $1,000 a month. This new law passes. The guy across the street is getting $2,000 a month for the same unit. By how much can I raise my rent?
It's going to be whatever the municipality awards, which could be, for example, in Los Angeles, 3%.
So what you're saying is that there are now municipalities that do not currently have rent control that will have rent control.
Exactly. And protect yourself while you can.
Okay, what do the odds makers say on this bill passing? What's the over-under on this?
Well, we thought that next year the legislature was going to do it by their own volition, that it was going to be voted out Costa-Hawkins. But now that I see that there's a movement to get this onto the ballot as an initiative, I have no doubt that this is going to be on the ballot, and I have very little doubt that it will not become law.
Oh, the door.
And we are back.
And I am closing the door.
Why are you doing that?
You want the door open or closed?
I think I want it open.
Okay, you
Go.
want it open?
No, I'm kidding with you. Go ahead.
Okay, we are back with the Landlord Tenant Radio podcast. And forgive the brief interruption for technical purposes. Dennis has to cough up a little more money for better equipment. Having said that, Dennis, at Parkside Management, anytime we have an eviction, we call you, like it or not. And we recently gave you an eviction where it was a contested eviction. Explain to our listeners in TV land what it means to have a contested eviction.
Well, in any kind of a lawsuit is going to be filed with the court, and then that lawsuit is served on the defendant. It could be for a breach of contract, for someone failing to pay an invoice or something, or in the case of landlord tenants, it was going to be a type of lawsuit that's called an unlawful detainer. So that lawsuit is filed with the court. Presumably the tenant didn't pay the rent, for example. A lawsuit is filed with the court, and this type of an eviction or an action is seeking not only possession of the premises, but it's also seeking all the rent owed on the premises. And once the tenant is served with that paperwork, the lawsuit, they're going to have a certain time to contest the proceedings. They could either say, I'm not going to contest, I agree with this, and I'll let the lawsuit take its course, or I want to have my day in court, so I'm going to file a response. That's called an answer, and a trial date will be set up, and that's when the parties will be determined by a judge or potentially by a jury who is the winner and who is the loser.
Question, sir. What percentage of the cases that you get are either A, contested, or B, not contested?
I would say right now about 35% of my cases are contested.
Contested.
Contested,
Okay.
where we're going to need to make a court appearance on those cases.
Okay. Do you think that if the tenants that are being evicted are wise enough, informed enough, however you want to put it, to know that if they contest an eviction, it gives them leverage with the landlord to stay there, because they're saying to themselves, look, I can go to the Shriver Project, I can get a lawyer for nothing, and this guy, my landlord's going to be out of pocket for Dennis Block for thousands of dollars. I'm going to play the game.
Okay, well, you're kind of jumped ahead a little bit. There's the people who just contest the case with an attorney or without an attorney, and that is a relatively inexpensive situation where you're going to have a trial set up in about 20 to 25 days. That trial is going to be heard by a judge, and generally that case is going to be over within an hour or two. So while there is additional expense to a contested case, it's not that big of a deal.
Wait a minute. Let's be candid with each other. When you say a contested case is not that big of a deal, let's do some role playing here, Dennis. I call you, I hire you for an eviction, and you tell me that the tenant has filed an answer, and now I am going to be, you are informing me that there will now be a trial. Okay?
Exactly.
Exactly. So when you say it's not that big of a deal, I am a landlord who is of meager means. What does that mean to me in terms of my financial outlay simply to bring this matter to trial? Give us the meat and potatoes of this.
Well, for my firm, for example, a court appearance to do a trial that lasts up to a half day is only $350. And that's it. However, what you alluded to is the tenant who plays the game and asks for a jury trial.
That's what I'm referring to.
Well, yes, but
So how much is
most cases are not jury trials. There's only a very small percentage
Okay.
of all of our cases are jury trials.
So help me understand this. There can be a contested eviction where the out-of-pocket for the landlord is $350.
If we're going to talk, yes, I mean every attorney and law firm charges their own fees, but this is what we charge for a court appearance lasting either the morning or the afternoon.
Okay, that is assuming that the tenant does not demand a jury trial.
That is, of course.
Okay, now, $350 for a contested eviction, no jury trial. Now, Dennis, we gave you an eviction to handle for us. The tenant's answer claimed issues of habitability. Then a week later, they claimed issues under the Americans with Disabilities Act. And then the invoices started to come, quite frankly, and again, from the landlord's perspective, what is he expected to pay for an eviction for a contested lawsuit that requires a jury trial? And part B of my question, Dennis, is what can you tell the landlord that he can do proactively, or that your firm can do proactively, to reduce his exposure to what could be what, $5,000, $6,000, $7,000?
Easily, and quite frankly, those fees in the realm of what attorneys charge are actually tremendously inexpensive. A normal jury trial by a regular law firm in this town would be anywhere from $20,000 to $30,000 before you blink. Obviously, there are people in the unlawful detainer field, such as my firm, obviously are going to be charging less for that. But again, you're kind of missing the point. There really is nothing proactive that the landlord can do. The landlord has a problem. Let me finish. The landlord has a problem. And the problem is the tenant's sitting in his unit and he's not paying rent. That's the problem. So unless the landlord is willing to donate that unit to the tenant, he's got very few options. He's obviously asked the tenant for the money. The tenant's refused. Now you've got to take the legal route. Now, no one knows what's going to happen. No one knows what's going to happen when you file an eviction lawsuit. You file the lawsuit. Maybe the tenant's not going to contest the case. That's going to be simple.
But you're jumping the gun. There, I submit to you, kind sir,
yes,
and wise sir, that there is an opening like a running back hitting an opening between the tackles, between the time the tenant does not pay the rent and the time he files an eviction. And what I'm getting at, sir, is this word, settlement. Can you please talk to the landlords out there about how your firm could help them settle a case without having to incur the expense of an eviction?
If the landlord has come to the attorney's office and wants to commence an eviction, he has obviously had conversations with the tenant. You're in property management, okay? And in your particular case, I'm sure the first thing you didn't do when you saw that it was the 2nd of the month, and therefore my next step is to call Dennis Block. I'm sure as a property management company, and a very good one that you are, you would have had some discussions with that tenant. But a letter, let me cut to the chase here. There's a big difference in credibility between Zach Lawrence sending the tenant a letter saying, pay your rent or you're going to be evicted, and Dennis Block sending this tenant a letter saying, pay your rent or you're going to be evicted. Am I right or am I wrong? I think you're wrong.
You think I'm wrong?
I think you're wrong.
You don't think that if a tenant gets a letter on your letterhead stating that we have everything we need in place to file a successful eviction, this is your last chance to get current and pay the landlord by a date certain, you don't think that's going to have any weight whatsoever? In other words, you're basically saying that there's no option.
In most cases, there is no option. For example, if I wrote you a letter today, and I'm being serious, that I'm going to file a lawsuit against you unless you fly to the moon.
Oh,
No, I'm serious. Let me finish my thought, though. Okay, if the tenant doesn't have the money, it doesn't matter what threat that you're going to have.
But you're assuming, Dennis, you're operating on the assumption that the tenant doesn't have the money, and you know better than anyone else in this planet, okay, that tenants often do have the money, but they still, they decided to buy a Christmas present. They decided to go out to have a nice dinner.
Then they don't have the money.
And the landlord could wait for his money. You know that.
But that means the tenant doesn't have it.
He may even have it.
Listen, prior to most of my clients, prior to coming, and I don't know why we're even on this topic, but most of my clients prior to calling me have served the tenant with a legal document. That legal document is a notice to pay rent or quit. It says clearly on that document, you've got 3 days to pay me. If you don't, I'm going to be filing an unlawful attainder, an eviction record. We're going to be seeking the rent owed, and we're going to be seeking your eviction. That enough would make most people who had the money would pay the money, and most times a tenant that does get a 3-day notice is going to pay. But if my clients do not want me at the start of a case to send a please letter to the tenant, what they're looking for, at least my clients are looking for me to file that lawsuit as fast as I can and serve that lawsuit, because they know in all truth and sincerity that the only way they're going to get satisfaction is not by a settlement because the tenant doesn't have the money, or they don't want the money at that point. They really want the tenant to vacate the premises, so they want to go through the legal procedure to evict this tenant.
Okay, if I'm hearing you correctly, there is absolutely, positively zero benefit to a landlord to call you up and say, Dennis,
there is nothing absolute.
I've been doing business with you for years. You're the best lawyer in town. In this particular case, the tenant was served with a 3-day notice. The 3-day period has expired. And Dennis, I want you to send this guy, let's call it for what it is, a scare letter saying, look, we're taking you to court, and you still have a small window of opportunity to make things right.
Nothing would prevent me from sending a scare letter if that was the wishes of my client. If anytime you start a case with us and you say, Dennis, don't file, send them a letter where you're going to tell them all the eventualities, I would be happy to do that.
You would be happy to do that.
I think, with all due respect, I think that the likelihood that letter would have any effect is nil, zero.
Okay.
So and then what you've done is now you've wasted another 10 days, you're going to prepare a letter, send a letter, give them a week to step up to the plate. And in that situation, you're just wasting your time. Because what you've got out there is people who are either have no money, so they can't comply no matter what. It's like my comment about flying to the moon. They can't do it no matter what. Or you're dealing with a type of individual that is trying to take as much money and stay on the property as much time as they can, because the longer they stay on the property, the less they have to pay, and that's what their motivation is.
Okay.
And we're back on the air again.
We're back on the air.
Discussion.
Folks, don't buy equipment at Radio Shack. Okay, that's the lesson I'm getting out of this podcast.
I hate this guy.
Okay, so Dennis Block, do you believe that it is a good investment for a landlord to fork out $7,000, $8,000, $9,000 in order to get a, as you call them, a malcontent out of their unit?
Okay, first of all, when an eviction case is started, your position is that every case is going to be a jury trial where the fees are going to be into the thousands of dollars. That's not the case. It's an incredibly small percentage, maybe 5-6% of my cases now. Most of the cases are dealing with situations where the tenant doesn't fight, or if they do fight, you're dealing with just a simple bench trial in front of a judge.
You said 35% earlier. What was that percentage about?
35% of the cases are contested, but really only about 7% of the cases are jury trials. It's a very small percentage. So to think that you're going to be spending thousands and thousands on every single case is not what's going to happen. However, writing the tenant a letter generally is not going to be effective. That's my experience, and I've had a lot of experience in this.
But you don't have a problem doing that.
I don't have a problem. If a client has said to me, and it certainly has happened, please send the tenant a letter explaining that you're going to be filing a lawsuit,
right,
and the significance of that and how it's going to affect his credit and his ability to lease other units. Of course I would do that.
Thank you, sir. And Mr. Block, how much do you charge for that particular service?
Generally for a letter we charge $275.
$275. Okay, so basically, if I am price sensitive as a landlord, something I should consider. Would you say so?
I have no problem with it. I don't necessarily agree with you.
Okay,
but I have no problem with that.
Okay, let me shift the subject about something. Now, your very talented and lovely attorney Denise taught me this, and I'd like to discuss this with you. When a roommate moves out, let's say you have a unit with 2 tenants. One of the 2 roommates has given you the 30-day notice, he's moving out, and then another guy wants to come in. Now, I had 2 discussions with her. The first one, during the first one, she told me that you don't necessarily have to allow a new tenant in as long as you decrease the base rent by 10%. Would you comment on that, please?
Okay, you're saying that originally there were 2 tenants.
There were 2 tenants, 1 and 2. Tenant 2 gave you his 30-day notice that he's moving out. Tenant 1 said, oh, I've got a friend that now wants to move in. He'll be applying for this unit. According to Denise, and we've had 2 conversations, the landlord doesn't necessarily have to allow that new person in if the landlord is willing to give a 10% reduction in rent.
Okay, I don't think that's the law at all.
That is not the law.
No, in the city of, and you probably misunderstood.
Now what she just told me also, to clarify her matter, because I know she's very knowledgeable, is that you may not unreasonably withhold permission for this new person to move in.
Yes, when you have a tenant who moves out, the remaining tenant can ask you permission to bring in another tenant. The landlord, by law, has to allow that, but he can check his references and can check his credit, and assuming he is qualified, the landlord would have to rent to him. You cannot get an additional 10% for this person moving in. You're kind of confusing different rules. If another tenant, a third tenant, wants to move in, under LA rent control, you are allowed a 10% rent increase if you allow that third person to move in.
We're not talking about a third person. We're talking about tenants 1 and 2. Tenant 2 has moved out. Tenant 1 now wants to bring in a new guy to replace tenant 2. What are the landlord's duties and obligations?
The landlord has to allow this tenant in, though he is allowed to screen the tenant And if he qualifies, the landlord must rent to him under LA rent control rules.
Must.
And there is no additional rent that can be charged.
Okay, now, let's say that the new tenant just doesn't satisfy the landlord's requirements legitimately for economic purposes, whatever. Does the landlord have to keep allowing applicants to come through until somebody qualifies?
That is accurate.
Really?
Yes.
Really? Okay, so where am I getting 10% from? Is that just a number that was floated in the air? Diminution in value, 10%? Help me understand this.
And I tried to, and you kind of glossed over it. I said the 10% rule is only if there's an additional tenant
Yes.
joining the tenancy.
Yes.
The landlord under the LA rent control ordinance is allowed a 10% rent increase. That's the only 10%
All right.
increase.
So if tenants 1 and 2 were the original tenants, and then tenant 1 and 2 calls you and says, Dennis, I want to add tenant number 3, you can say, sure, I'll look at his application, but guess what? Your rent is going up 10%.
Absolutely.
Okay, that clarifies it. You see, Dennis, I'm here to help.
I think you're here to confuse.
Okay, folks, you're listening to the Landlord Tenant Radio podcast. My name is Zachary Lawrence of Parkside Property Management. We've been doing this for probably too long, but you know something, Dennis, and I mean this. People are coming up to me and saying, Zach, you know what you're talking about. And if I do know what I'm talking about, it's because of everything I've learned from you over the last 20 years. I really mean that.
You're the man.
Okay. No, you're the man. Okay. Tell me about posturing. Okay. When a tenant is being evicted, again, we gave you a case. Suddenly, the unit is not habitable. There's no running water. The roof is leaking. It's almost like Charlton Heston in the Ten Commandments. All of these plagues suddenly start happening. And on top of that, we do an inspection and we determine it's a lie. Okay, then we get another letter from the landlord's, from the tenant's landlord, from the tenant's attorney, saying that, oh, he just had a kidney transplant, and under the American with Disabilities Act, you cannot evict him. Dennis, I may not be the sharpest knife in the drawer here, but what is going on?
They're using any and every tactic that they can to forestall their eviction on these types of cases. It has nothing to do with the truth. The landlord, in I would say 98% of the time, has never been told of a problem with the premises. The landlord is waiting for his rent, serves a 3-day notice, magically the tenant doesn't pay, and then all of a sudden you're getting a laundry list of things that are wrong. So it's really the I don't have the rent scenario, which then triggers the tenant to claim that there's lots of things wrong with the premises. I would say that this happens almost in 100% of the cases. And in every case, my client is telling me clearly and without reservation, he never told me about anything. Most landlords, as you know, as a property management company, if there's something wrong with the premises, the tenant calls them, they're going to go over and fix it. There's never any intent on the part of the landlord, for most cases, to not fix a unit where a problem exists. However, in almost 100% of the cases, the tenant is creating the problem with the premises, not informing the landlord, first calling the health department or the city to come down and inspect without even talking to the landlord, because what they're doing, they're posturing. They're posturing to see how much rent they can steal from the landlord, and that's just what it is. It's legal theft.
Okay, when you have a situation like that where there's posturing without any legal foundation, and the landlord is faced with, again, a contested eviction, a jury trial, thousands of dollars in legal fees, if you, Dennis Block, can prove that this tenant was talking out of both sides of their you-know-what, okay, are you going to ask for legal fees?
Well, in most cases, the landlord's rental agreement by choice has limited attorney fee provisions.
What does that mean?
It means that there is a maximum cutoff for what the attorney fees can be. Usually it's $500, because if in fact the landlord loses the case by some technicality, the landlord would be forced to pay the tenant's attorney's fees, which can raise $20,000 to $25,000 and even more. Of course, if the landlord got a judgment against the tenant for that attorney fee amount, the chances of collecting it would obviously be very slim. But when you're dealing with a judgment against a landlord, that's easily collectible. So we always recommend in all rental agreements that we have an attorney fee limitation, and of course that we're hoping that dissuades tenants' attorneys from going through a 3 or a 4 day jury trial, because they know at the end that the most that they can win is $500.
Mm-hmm.
But it is incumbent upon the
Is that something that'll stand up in court, that clause, that attorney's fee clause?
Without question, it's been tested, and of course it's been upheld.
Now you have something in your lease, Dennis, that waives a jury trial, do you not?
Of course.
Okay, why is that there when you and I both know that that's not enforceable?
It is not enforceable under California law, but we put it in there because we hope that it would dissuade someone from requesting a jury trial who's not knowledgeable on the law.
Ignorance is bliss.
Right. But let me go forward with this, though. I can tell you that most jury trials that we actually do that don't settle, we actually win. And the way we win it is very simple. We catch the tenant lying. And that happens almost in every case. We always send out discovery, which is a series of questions for the defendant to the tenant to answer. And invariably, when we have them on the stand, they look like the biggest liars. And generally, even though people think, well, gee, a jury is going to be made of mostly tenants and they're only going to be for the tenant, it's not the case. Most of the times when we actually bring the case to conclusion in front of a jury, we're winning. And we're winning on the basis that the landlord is really telling the truth. And the truth really is in the side of the landlord.
Do you mind if I make book on some of your jury trials, like in Vegas? Like I could put a little bit of money down, lay odds, and if you win, I get like 3 times my money back?
I'll tell you this. Let's talk about that after we turn the podcast off.
Okay, folks, I think we covered a lot of ground today, and that's the intent of this podcast, to keep you informed and to tell it like it is. So, Dennis, as always, tell our listeners how to reach you.
Well, hopefully our next telecast will be a little bit more professional, had a little battery and connectivity
He's
problems.
talking about the technical aspect now, aren't you?
Of course.
Okay.
But if anybody needs to reach me, I got a toll-free number, and Zach didn't even realize, but right behind me is that toll-free number. It's 1-800-77-EVICT, that's EVICT, or catch me on the internet at evict123.com. You guys got a question? Call the office. You'll talk to an attorney and their charge will be 0.
And I'm Zachary Lawrence of Parkside Property Management, parkside123.com, saying so long. See you next time on Landlord Tenant Radio. Dennis Block, good afternoon.
And good afternoon to you.